Mr. Birss.
Thank you, Arnold. My second topic for Ground 23 is to look at the facts. I'll take the US facts. There's not little between the parties on the US facts. I'll just stress a few points, 7 points on the US. Then I'll go to the UK facts, and that's in a bit more detail because I'll need to turn up quite a few documents. But on the US proceedings, I think you know, your Lordships already know, and I think it's in the chronology, that they were commenced by Optis at more or less the same time as the UK proceedings. Secondly, Apple clearly had no prospect whatsoever of challenging jurisdiction with respect to proceedings based on infringement of 5 US patents. Thirdly, as your Lordships will know, there have been 2 jury awards, first instance, and the first has been replaced by the second. The first was $506 million for the past only, and that is relevant to some of the issues we're discussing. And the second, which is now the current one, is for $300 million for past and present. Sorry, past and future. Fourthly, there was an application by Apple in April 2021 before the retrial of the damages verdict. So when the verdict was still...
Sorry, when you say past and future, future down to what date? Forever?
To expire in the patents place.
Expire
yes.
the patents. Thank you.
There was an application in April 2021 by Apple in the US proceedings before the EDTX. I'll give you a bundle reference, I'm not going to turn it up. It's in Selwyn 5 at SUP 3, tab 10, 7274. There, Apple asked the EDTX to order Optis to show cause how the simultaneous pursuit of royalties for the same patents in the US and the UK was proper, does not pose a risk of double recovery. The motion was opposed by Optis. EDTX declined to stay or delay the retrial of the assessment of damages. And the documents, I think that there were quotations in Mr. Selwyn's witness statements. As you've heard, my lords, the $300 million jury award is currently on appeal to the CEFC.
Sorry, you've left us on a cliffhanger there. You've told us an application was made and it was opposed, but you haven't told us what the result was.
No, I thought I did. I took it too quickly. EDTX declined to stay.
Right.
So Judge Gilstrap, he said, although the motion was put the way it was, but he said, I declined to stay or delay the retrial of the assessment of damages.
So I'm assuming from that he proceeded on the basis that that was a matter to be sorted out in the English proceedings, not in his case.
Well, it was more along, yes. Yes and no, because he said, well, if there are issues of double recovery, we'll sort those out when they arise.
So he left open the possibility of double recovery being sorted out in the US proceedings?
Potentially.
Thank you.
And then the US jury award, the US $300 million jury award is currently on appeal to the CEFC. And Apple appeals the various, the detail is given in J1, Supplementary Core, tab 40, 261 and following. But Optis cross appeals to reinstate the $506 million. That's the original jury award, damages for the past only. So the range of possible outcomes, because there are also issues around the appeals against the finding of infringement and the finding of validity. And so the range of possible outcomes ranges from $0 with no retrial to $506 million for the past. If the result were $506 million, Optis could argue that they're entitled to future royalties too. And to give an idea of scale, $506 million was for 18 months of infringement. But I should draw attention to Moss 35, who said that his instructions were that Optis would not pursue its motion for ongoing royalties, but no undertaking has been given in the US proceedings. There is currently before the CEFC, and it's not been rejected, and learned friend said, an Apple motion to stay the proceedings before the CEFC, that's to stay the appeal. That application has been referred to the merits panel. So I understand it, that doesn't necessarily mean that it will come up at the oral hearing, but it is going to be decided by the same panel. And the last point is just on the merger point, because when my learned friend was making submissions, I stood up on one occasion, learned friend said that he referred to the cause of action being extinguished, And then when I
Merged in the judgment, yeah.
Yes, well, indeed. But your lordship's question, which was, I stood up just after that. And so, is it common ground that merger is a common feature of both systems? That is common ground. Of course, what I should have said when I stood up was that it's the extinction of the cause of action which is not common ground, and that's for the reason given by Mr. Sheasby, who is the Optis's lawyer, one of Optis's US lawyers, at Sup 3.1/15. He said that merger occurs, quote, upon exhaustion of all appeal rights, close quotes. That's 45C Roman 6. The Lordship would like to turn that up. So it's in Sup 3. Take tab 1 at page 15. In the middle of the page. It's the second sentence of 6. Upon exhaustion of all appeal rights, Optis only rights in respect to the matters decided by the judgment are claims or remedies as appropriate to enforce the judgment and or to enforce the undertaking of the judgment. The underlying cause of action is merged with the judgment. So that's one part of the merger thing, but of the merger issue. But 3 takeaways in US proceedings. First of all, that the position in the United States is in a state of flux. We don't know whether what's going to result in the United States is going to cover past and future, whether the relevant patents are going to be found invalid. One might think that's improbable. Or it's a possible scenario. That's the first thing. The second takeaway is that the CFC appeal is currently proceeding to an oral hearing, which is likely to be soon. It has not been listed for April.
I thought that was prevented by the judge's order.
Lord, no. It isn't. And Optis say that they're prevented from doing anything, but the judge, this is really straying off into ground 24, but the judge has given guidance on what Optis made, I think 3 or 4 applications, and the judge has said that reply briefs could be filed, that a motion to stay could be filed and defended.
All right, let me rephrase my question. Do you accept they can't appear at an oral hearing without a further application to the judge?
I accept that they don't need a further application to... No, I accept that they don't need a further application to the judge to appear at the oral hearing.
Right, okay.
And
So
indeed...
you accept that they don't?
They don't need to appear to the judge. We're straying into ground 24, but 6.2 does not require, before you take steps in the United States, it says don't act inconsistently and gives you an option if you're uncertain to apply to the judge. But, if it's convenient, Lord, perhaps we should just go to 6.2.
Yeah.
So it's in call 3. It's at 349, tab 10. Page 349. Perhaps should start at the bottom of page 348. You see the introductory words of 6 there. Without prejudice to any right to appeal or seek permission to appeal these proceedings to stay, save that. Then it's subparagraph 2 which interests us. So each Optis and Apple are obliged to do nothing inconsistent with or prejudicial to the future operation of the court-determined licence.
All right, so when they applied for extensions of time for reply briefs, was the response from the judge, you don't need to do this?
But he gave them permission.
Is shaking his head. So
Sorry,
the judge seems to, Mr. Speck shook his head when I asked the question. So the judge seems to have thought that even just asking for an extension of time for your reply brief was something that they needed to do.
Look, well, I'm saying today that I should say, Optis are going to appear at the oral hearing, no doubt. Optis in September 2024 gave notice to the US court gave notice to the US court that they were going to appear at the oral hearing. They were asked for their availability, and they made no mention. If their position was, we can't appear in this court unless the English court gives us permission, that would have been the moment to do it. But they didn't. So they evidently feel they can take steps, contrary to Mr. Speck's submissions, they can take steps in the United States.
Thank you.
Obviously, they can apply to the judge with greater certainty, and the orders the judge has given so far do give a greater measure of certainty than the provision on its face. But there's not a requirement, and of course subparagraph 2, whilst we're on it, so there may be an application, and in 3, each of Optis and Apple may apply to this court for any order appropriate to maintaining and or preserving the effective future operation of the court-determined licence. We'll obviously have to come back to that. So, so in terms of we don't know how imminent this appeal is in the States. We think it's likely to come on apparently a few weeks ahead, about 5 weeks ahead, I think. The timetable is scheduled for, we've passed the April deadlines. It's not going to be in April. It could still be in May and subsequent months. If there were a UK global license to assigned, Apple would then be licensed to the US patents. Despite Optis, and this also relates to the merger point, despite Optis' arguments that they can't, Apple would then argue, obviously there's litigation risk in there, that Optis would lose its constitutional standing or that the US proceedings would be moot by reason of Apple being licensed. And Optis, it seems, no doubt would argue, I suspect, would argue merger, but they may well also argue waiver, because we've seen those arguments canvassed in Mr. Shesby's evidence. And it's just important to note, my lords, that this argument, any argument from Apple about mootness and constitutional standing, is much more uncertain if the US proceedings become finally determined before the licence in the UK is signed. That's why the gap to which Ms. Justice Smith referred to in paragraph 91 of the consequentials judgment is of some moment. And I should say that point about mootness and merger, the reference to that, you'll just note, is Selwyn 3. I won't turn it up. Selwyn 3, sub 3, tab 5, page 48, paragraph 23 to 24, and following. So I must then come to just give me a moment. So turning to UK proceedings, I start in MOS 2. This is where I'll have to turn up a certain number of pages. So it's in Sup 4, tab 21 at 202. And unfortunately, MOS 2 is partly in here, and there's another reference in Sup 2. I'm going to this one first, just because it's the only reference in Sup 4 for a little while, and then we can go to Sup 2, and there are several references in there. So this is 202, paragraph 3. He says why he's giving this witness statement. It's because, in fact, the proceedings, although issued very close, I think they were issued in the US in the afternoon, US time, and in the morning, the following morning, UK time. So US proceedings were on foot. When this statement is about serving Apple out of the jurisdiction and the basis on which that permission was sought from the English court. And so he's giving this witness statement in compliance with duty of full and frank disclosure. Then he quotes what has been said in the Texas complaint about, one notes at the end of 140, in the quotation, UK FRAND proceedings will determine FRAND terms of plaintiffs' worldwide portfolios. And then 141 refers to the Fran Declaration, and to the extent necessary, the last line, that should be subordinate to the UK Fran proceedings. In this witness statement, he actually goes a bit further than that, and I do rely on that difference. But in 7, he explains why he's wanting to serve Apple, a US corporation, in the United States, when he's already got US proceedings ongoing. So, page 203 of the bundle, the claimants commenced this action in Texas so as to preserve its position with respect to the overall claims. Specifically, while the claimants believe that the case they have commenced in this court is properly found and is fully justiciable, this court is the appropriate forum, that may not be accepted by the defendants and they may mount a jurisdictional challenge. And then I just jumped down about another three lines down. On the right-hand side, the sentence starting, in the event, which I stress I consider to be highly unlikely, this court concludes the action against third defendants not justiciable in this court, or that England is not the proper forum, then the claimants wish to preserve their right to take action against the third defendant in the courts of the United States. Furthermore, even if this court were to determine the terms of the Fran licence, there's no certainty the third defendant would sign up to that licence. True it is that potentially the consequence of not signing that licence might be the third defendant would be subject to an injunction, always assuming the claimants succeed in establishing that one or more patent suits have been infringed. But in terms of damages for past infringements, these would be limited to damages arising in the UK. So those are the contingencies which he's taking. I need then to turn to SUP 2, so I think we can put SUP 4 away for the time being. And that is then tab 31 in SUP 2. So still in the same witness statement, in fact, it's just one of the different bundles. It's page 185, paragraph 11 at the bottom of the page. If your lordships have that. While it's possible the defendants may seek to argue this means that, it's just rehearse the background and mention the EDTX proceedings. While it's possible the defendants may seek to argue that this means that...
Paragraph 10 refers to the date difference to which you reverted
Indeed.
A moment ago.
Yes.
He says the explanation is set out in the confidential annex. I mean, do we
know
what the explanation was?
I'm not conscious I've ever seen the annex because I wasn't around in the case at that time. I only came after trial, and I've asked about it, but it seems the explanation is simply that I don't know why it's in a confidential annex, and I've never inquired, I've never perhaps sufficiently inquired, but all I know is that it was within hours, within the same 24-hour period, proceedings were issued in the States and in the UK. And so, 11. While it's possible the defence may seek to argue that this means the courts of EDTX are first ceased dispute between the parties, seek to suggest that this has a bearing on the issue of forum convenience service out, I do not believe this is correct because, 1, the nature of the claim in the EDT being concerned with different patents, UK patents could not be litigated in the EDT. 2, of the nature of the way in which any Fran issue is raised or mentioned is expressed in contingent terms in favour of these proceedings as set out above. And 3, the de minimis time difference between the precise moments of issue, making the point one of technicality and substance. So we do rely on the fact he's telling the English court.
Well, can I have your answer to the question that's raised in that paragraph? Is it your client's position that EDT was first seized?
It isn't, Lord.
It is.
Sorry, no, Lord, I'm
is
not.
It your client's contention that EDT was first seized?
Lord, I'm not arguing a jurisdictional
question.
Do
you accept that they were seized simultaneously?
Well, Lord, as I'm not arguing any jurisdictional application, I'm happy to accept that. But the point is not what I think.
To be clear, you are content for this court to proceed on the basis that the two jurisdictions were seized simultaneously?
Lord, I am, but I do rely on the fact that Mr. Moss was here invoking the jurisdiction of the English court to serve a party, a US plaintiff, a US defendant in the States. And in order to do that, he was mindful that there was a risk of a jurisdictional application, and therefore he made this representation to the court as part of his full and frank disclosure.
To be sure, absolutely. But I just wanted to be clear on the first seize point, because I understood from Mr. Speck that his position was that he was content for the court to proceed on the basis that the two jurisdictions were seized simultaneously, And I now gather from you that you are likewise content, and therefore that's one less issue for the court to have to consider.
I'm sorry, my lord, I was overly defensive. I'm sorry about that. I should have said yes right away. But at once, sometimes reluctant to accept everything that the court puts to one.
I don't know where it goes.
Well, indeed, my lord, I was trying to think. Anyway, there we are. So it's a point. It's part of the factual matrix. Then I must go to two orders of the court. Two orders of Mr. Justice Smith. His first appearance in these proceedings, as I understand it, from my learned junior, it was on the 1st of July 2021 in the CMC. That order is in Sup 2, so the same bundle, tab 19, at 80 to 81. And the... Sorry. So this is so page 80. So it's been a CMC, and on page 81 sees Mr. Justice Marcus Smith has become the docketed judge. And then it's paragraphs 1 and 3 in particular, in conjunction with 8. And so this is save as consistent with the following paragraphs of this order. The case management directions in paragraph 1, given in the orders listed Appendix A here too, in respect to trial A proceedings, are hereby varied. There have been various case management hearings going back to a hearing. I think the first one was in front of Mr. Justice Morgan at the beginning of these proceedings. Then in paragraph 3, the parties shall, by 26th November, set out their positive cases in respect of the issues to be determined at trial E. Such positive cases shall be set out by way of position statement, stating the parties' cases, and written evidence of fact and expert opinion relied upon in support of same. We can follow it through, but what our position is that the issues to be determined at trial E are those matters which remain after the resolution of trials A, B, C, and F. D and F. And that's the first order. And then the second order deals with a further aspect of the pleadings. It's an order which is it's only in Sup 5. We still need I'll need Sup 2 in a few minutes, but I've got a Sup 5 reference followed by a Sup 1 reference. So, whether your Lordship may prefer to push it away. So, Sup 5 at 1, tab 1, is an order of 29th of October 2021. And it's particularly paragraph 3, the identification of licence drafting issues. The parties shall identify the issues of licence drafting that will require the court's determination according to the protocol set out in Wilmer Hale's letter of 28th October 2021. We have that letter in tab 21, page 81. My page reference is page 81 is the second page of the letter, and I think that's the material part of the letter. You can perhaps just pick it up right at the bottom of page 80. So the paragraph 1 is about exchanging the positive cases with a date for that. And then secondly, the parties will engage with each other in the licence terms in the new year, considering all the material. This is the period of negotiation referred to in your letter. And we do not think it's productive to direct that the parties should exchange markups by 21st of January 22 based on the pre-existing licence offers. What I infer from that sentence is that Optis has been contending there should be an exchange of licence markups. We suggest that they should be encouraged to debate the terms fully with a view to reaching an endpoint of 25th of March 2022, the Friday the week we propose. The negotiations can be on a without prejudice basis. The endpoint would be the production by the parties joint as far as possible of an open document, the schedule. We now know that was not done. Indeed, there's a reference, I think, in Mr. Besant's evidence to an agreement between the parties that, in fact, Optis' preferred option, that is the exchange of markups, was the way in which this procedural order in the order of 29th of October 2021 was in fact implemented by the parties. And so what we say to that is that it makes these markups, which Malone Friend rather treated this as something which just happened, as, in our submission, a part of the pleadings. And then, so then I go to the first of those markups. That's the Optis markup of the Apple draft license. That is in SUP 1, tab 18, at 233. And I'll take it. I'll pick it up just because it's to look at the release clause in 235. So this is Optis marking up Apple's original 2018 version of the of their proposed license. And you'll see beneath beneath clause 3, you'll see Apple's wording is crossed out in toto. So release, Panoptis hereby releases, etc. So that's crossed out. And Optis put forward their own wording, which, and one notes in 3.1, your lordships will be, I'm sure, far more familiar with I than the drafting of patent licenses, but I'm told this is standard form of drafting. And so, in considering the payment set forth and subject to full receipt, Panoptis hereby releases the extent of its right to do so, Apple, in respect to any patent infringement arising prior to the effective date of this agreement. Then you'll notice the release limitations inserted by Optis. The release in section 3.1 does not apply to any persons which Apple acquire after the effective date. So that's after acquired entities. And it shall not apply in 3.2b to any cause of action based on a breach or misrepresentation of fact in connection with this agreement. So those are the limitations. And then, obviously, we draw attention to the fact that is Optis wording. And then I come on to Apple's markup of the Optis draft, which was exhibited to Mr. Ankenbrandt's witness statement. He's not a minor witness, my lord. Nobody who is the principal negotiator for Apple on some of the contracts which your lordships have seen is a minor witness. He didn't negotiate anywhere near as many as Miss Muse of the contracts in issue, but he was still an important witness for the defendants. So that's up to tab 48 at 325 at 327. And your lordships will see that, in fact, this clause, which is the release clause on 327, it's the first part of the clause has been cut off, unfortunately, in the effort to try to reduce the number of pages, unfortunately. But the additional page is in the bundles, for your lordships' note. If your lordships would like to see it at your convenience, the clause starts at SUP 5, tab 15, page 63. And if I recall correctly, I have seen it. It's mainly in black with some minor amendments made by Apple. But then it's particularly 3.2 and, well, it's particularly 3.3. The licensor shall, at his own cost, take all steps necessary to secure the dismissal of claims brought against Apple alleging infringement of any of the licensed patents in any litigation in jurisdiction, including the EDTX proceedings. And that is to be with prejudice, which is explained in the Shesby evidence, I think, if I'm not mistaken. And then, just a couple of lines down, licensor agrees, A, to take no action to enforce against Apple any order or judgment obtained in any lawsuit prior to the effective date, and B, to take no additional action to prosecute any lawsuit against Apple, including seeking discovery, disclosure, or costs of such requests. Apple makes no admission of infringement, enforceability, validity, liability, etc. And so, no doubt, this might be described as Baroque, or to use Optis's counsel's word, Rococo. Not being an expert on that, I wouldn't hesitate. No, it wasn't Mr. Speck. It was Mr. Raphael, to name him. I think we might see that on the transcripts, but there we are. So, obviously, we draw attention to that. Now, Optis, in its reply evidence to this, it was Blasius 7. That says nothing. I can give it also a reference, so you can see it if you want to turn it up later, but it's up to tab 53 at 347. But I should turn up the document in this bundle, which is the Stasic evidence on this, because Mr. Speck did rely on this. This is up to tab 52 at, I've got paragraph 18, so I'm not sure I should have a page reference there. Yes, I'm going to I'll start at 345 and I'll come back to Mr. 345 paragraph 18, because that's where Mr. Stasic, in his third witness statement, I'm sorry, I think our skeleton in fact refers to the second witness statement, but Mr. Speck is quite right. The relevant witness statement is the third witness statement, that comes after the markup. So I think this is just worth reading, because this is his comment about past release. So it's the very clause we've just been looking at. Apple's amendments to the release clause have led to release for past infringement being overly broad in comparison to license granted. This is because Apple have included the term license or patents as part of the release. And this is defined too widely, it says. This would effectively give Apple a license for its past actions in relation to patents, which are not the patents intended to be licensed under the agreement. So that's the respect in which he says that the release clause is too wide. And it was that, I think it was a separate subparagraph written in by Apple, that my own friend relied on, as if he went to this witness statement and he relied on paragraph 8, where some general general observations, he calls them, are made, and he says that including other matters would depend about 3 lines up to the bottom on the particular circumstances of the licensor, what's important to them. Part of negotiation, if a licensor were asked to grant additional rights, they generally expect to receive something in return, not to be compensated adequately for the additional rights granted. Then his point is the same point. Certainly, 4 lines down on 342, Apple's broadening of the definitions of licensed products to include all Apple products, rather than just mobile telephones and tablets, the introduction of the concept of license or patents, which would enable Apple to gain rights to patents other than those actually being licensed. The changes I'd expect a licensor to either reject or, if he's prepared to accept, to agree only with additional consideration. So it's just, we do obviously rely on the fact that by reference to the self-same clause, the objection taken is not the objection now taken. We say, on our side, it was unsurprising that there was no response to this evidence, no response evidence by Optis on the release clause drafted by Apple, because it was evidently common ground that there would be a full release as a result of these proceedings. And I say that because of the Optis markup of the Apple license. And what we do see, I put it no higher, but what we do see is that Optis is not objecting on the pleadings to the additional provision for dismissal. So then I go to, and I would just add, on the license markups as pleadings, if I could suggest after a conversation with known friend Mr. Nicholson, who's obviously far more experienced than I am in this field, but that the patent court has a history of innovation in various respects of pleadings, where Mr. Nicholson assures me such pleadings are not to be found necessarily in the White Book. And he gave me a couple of examples. Statements of case on validity, statements of case on infringement, that you would ignore them at your peril, was his point. So then I go back, I've just got to step back for a while, because Mr. Speck relied particularly on the position statement. That's the Apple position statement, which is in core 3. I think the way they are, they're done with sub 2 for at least a few minutes. So in core 3. It's core 3, tab 3, page 54. And you were taken to this by Mr. Speck. And he placed particular reliance. So it's headed on possible 54, provision to take account of any damages awarded in EDTX cases. He placed particular reliance on the last sentence. Any court-determined global portfolio license in the present proceeding should provide for any final damages award in the EDTX case to be taken into account when determining such royalties as may be due under the licence. And on the basis of that, the learned friend Mr. Speck said on the transcript, page 390 of the transcript for this hearing, lines 17 to 21 on day 3, its common position, the common position on the pleadings is that the EDTX case should proceed to a final award. We say no for 3 reasons. The first is that the pleaded case for Apple is that EDTX should be dismissed. That's in the licence markup. That, and of course, this pleading, which I'm in now, preceded. That was the plan of the judge, that it would precede the licence terms, the termination of the licence, the disputes arising from licence terms. The second point is that in any event, paragraph 39.3 does not accept that there will be a final award in the EDTX proceedings. The word is any. There may not be a final award. Patents may be found invalid. Retrial could result in a case management decision to stay those proceedings in the US, or the CFC might accede to Apple's application. But thirdly, this is the reality of what it was doing, what the status of this was on the balance of the pleadings on the eve of trial, was that if there is any award at the end of the day in Texas, so that Apple is potentially paying in Texas and also in London, then there must at least be some netting off those figures.
It also allows for Apple to say, well, the award in the EDTX is lower pro rata than the award in the UK, and to take that into account.
When your audit says pro rata, I mean the.
Or somehow.
Yes. I mean, and it is conceivable. I mean, had the Texas jury come in with
exactly.
with a very low figure, then it may well have been Apple seeking to rely on this. That's why we do stress the Supreme Court's approach to this, because it can't be at the option of the parties, as my Lord Justice Arnold, I think, observed in the judgment on Friday. Parties follow the money. They're all. I mean, there's no good or bad about this, because, in a sense, all the parties in the industry are looking to gain advantages in different places, and so
it's all about how much, and each party is fully entitled, as a matter of economic self-interest, to go for the most favourable outcome.
Well, indeed, my Lord. But the question is the role. Who has the choice in this, and does the court have a role? My submission is the court does have an important role. And that was my submission before lunch. I must show you, Lordships, for completeness, the Optis response position statement, which is in Core 3, Tab 4 at 100. This is the point I mentioned, the last point I mentioned in my opening words about Optis did rely on the Texas judgment on the validity point, on the better than average point. So this is page 100. So
I'm completely word blind, Mr. Mercer. Whereabout on that page?
Sorry, it's 42. So there are it talks first of 41B. Talks about the litigation outcomes from the Optis portfolio. So, I mean, 41. Optis disputes Apple's claim that those from whom Optis purchased its portfolio retained their stronger cellular patents. This was when the quality of the portfolio was fully in issue, and Optis pray and aid in B the litigation outcomes from the portfolio, and then 42 carries on with this point. So it's about litigation outcomes. It's about whether the litigation outcomes for Optis are better than average, and therefore this portfolio should receive a multiplier, which they were contending for, of 2 to 3 times just an average portfolio, as I understand it. And unfortunately, the document which shows that they relied on the text of proceedings has not got into the bundle. And so Mr. Marto in front of me I've got 3 hand-ups. They're just parts of documents which are already in, as I understand it, but they need to be added. And if I can pass up, obviously from...
So is this a complete set we're getting?
It is a complete set. So if you can try and give 3 seconds. And we've got a suggestion, because each of these documents already appears. Oh, sorry. You want more back?
Oh,
And because they already appear, we've got the tab references to put them into. So there are 3 documents coming up, my lord. One I need to rely on now is an extract from Optis Closing Skeleton. It's 462 to 463. And this...
so when you say 462 to 463, you mean...
Sorry, I mean paragraph 462 to 463.
I see.
And I've got a page reference for them. Oh, pass that sticker. So this would go into SUP 1, tab 3, suggested after page 56. Well, anyway. So, in fact, this section starts at 459. I should just pick up 459 because the heading, adjustment recognising other relevant history or value, litigation outcomes, and then the general submission, the overall submission is in 459. And then the 462 deals with China invalidation rates. And then the particular paragraph which is important is 463. The most important paragraph is 463. As to Optis' success rate in litigation, it's subparagraph C. In the US, Optis has succeeded on essentiality and validity on 5 out of 5 of the set families litigated against Apple. And Apple sought to suggest, and that's a mischaracterization. So it's relied on. And in the table at the bottom, my lords, you see the Optis family reference, UK, EDTX, Apple. There's a mention of the damages. I'm not suggesting that's germane to this point. There's a mention, but it's certainly the same patents, valid and essential. So all it is a conscious decision to pray and aid the Texas proceedings on this point, but not on value. I mean, I can mention in passing also that in the skeleton for trial, there was also a mention in, I think, paragraph 64 of Optis skeleton for trial, just mentioning the proceedings as part of the background. And witnesses also speak to the same. I think it was Mr. Besant. I saw evidence from Mr. Besant's witness statement, who talks about it, who's cross-examined, I think, by Mr. Bloch, maybe. He says that he used it as background. He used the EDTX proceedings as background. And so I then fast forward to July 2023, when the other two parts of the hand-up come into the frame. There's an extract from Trenton 39, which was one of the other two extracts. That should go, there's already some Trenton 39, in sub 3 at tab 6. And the suggestion is it might go before page 54. And this, of course, is after the main judgment. It's just before, it's in July 2023, it's just before the first of the 3 consequentials hearings. And so this is, because we say this is an important step when, given that there's been a judgment, what were the parties' proposals on the first of the consequentials hearings? And we see that in paragraph 6 of the extract. It's headed, Apple's commitment to the license being determined. Apple is committed to entering into the license agreement now. Although Optis' position is it does not wish to enter into the license agreement pending appeal, Apple is willing to do so now. In view of Optis' commitment and Apple's commitment, it's Apple's position there's no reason why there cannot be a license agreement now, despite Optis' potential appeal and some terms thereby being uncertain, including the rates. So this is the sort of position that has been adopted in certain other cases, such as the Panasonic case, by the parties in the Panasonic case, and the Lenovo versus Ericsson. Now, Optis' reaction in July 23, the July 23 hearing was that they'd never given a formal undertaking to enter into the court-determined license, despite the fact they said in their very first pleading that they wanted global license from their first pleading, and that Optis was willing to enter into the global license. And I'll take you to that, my lords, because it's the other handout, the other hand up, the last hand up. It's in the bundle. I'm sorry, this one's in the bundle. Sub 1, tab 23, at page 406. So this is the beginning, very beginning of what was a 4-day? Yes, 4 days including confidentiality hearing in July 2023. And there's some housekeeping. And Mr. Abraham says on page 7 of the extract from the transcript, that's page 7 of the transcript page numbering, under the heading housekeeping. We don't have the previous page, but Mr. Abraham says it is this. It's always been very clear that any undertaking given by Apple has been subject to appeal, so they will enter into a license, but will not sign anything until their appeals have been exhausted. That was always, the commitment was qualified in that way. There is an issue about whether my clients have given an undertaking, a binding undertaking, at all, as there was nothing recorded in a court order. Though there have been various statements made, there was nothing recorded. So there's a question about whether your lordship has the power to force my clients to sign. So, just to take, well, you can go on. I mean, to be quite clear, Optis did give an undertaking as part of this in part of this hearing, and that undertaking is recorded in an order of the court of 3rd of August of 2023. But it's just a reaction because Apple propose an immediate license now, and the adjustment. No, it's in the transcript. Yes, and then in that I should go back to the hand up. The last hand up was the July transcript That should go in sub 1 at 23, where we've just been. After page 409 is the suggestion. And it's the second page of the handout in the transcript page numbering 196. And Mr. Block talks about what Apple is proposing at 196 lines 12 to 18, and the judge comes back to him at the bottom of the page. So, if your lordships have this, page 196 in the handout. Can I just clarify one point, because it may be my own friend and I at cross purposes. We are, of course, proposing, I think my Lord's envisaging, that the agreement as executed, this is pursuant to paragraph 6 of the witness statement, and I think my Lord's envisaging, the agreement as executed will have terms which enable it to survive such changes as may be necessary once the matter has gone before the Court of Appeal. So that, and then the judge says, precisely so, what one has is conditionality and a provision to vary, but only by reference to what the Court of Appeal does. The reason he sees enormous attractions because instead of getting the usual, could the trial judge reconsider this particular point, one gets, so he over 197, there's greater certainty. We know where we're tied in. Mr. Block, we are committed to accepting it. At line 10 on page 197. And then halfway down 198, Mr. Raphael, things are coming on very quickly. One of the things I'm going to be saying to you in line 15 tomorrow is that so far as we've had time to address it, there is no power to order us to sign a license. Secondly, that revocability clauses cannot work in a satisfactory way. Certainly not on the other side's drafting or indeed in principle. They're wrong in principle. That's why the courts have done things differently. So he's pushing back. So the upshots I've already mentioned is that Optis did give an undertaking to sign after appeals. It did so whilst resisting Apple's suggestion to sign now. So I felt unrest to my left. I wasn't seeking to suggest that there was no undertaking, there was. And that's why, in a sense, that's part of the reason we're here. Then must just turn as I think it's my third topic, to the relevant paragraphs of the judgment and the true nature of Optis' criticisms.
So now everything can go away apart from...
it's core 1, core 2. There's quite a bit in, it's really the main effective judgment is in core 2, the first tab of core 2, that's the consequential judgment. But maybe I can just give your lordship the references. Just if you just take core 2, so I see where I'm obviously not flush with time.
Yes.
But so just a note in the main judgment that paragraph 24, that the judge cites the Supreme Court, paragraph 60, Newey, in support of licenses dealing with uncertainty. Now, the relevance of that, of course, is that one of the uncertainties can be whether patents are valid or invalid. Another uncertainty can be the outcome of proceedings in another jurisdiction. But licenses are capable of dealing with uncertainty. So the fact that something is uncertain doesn't mean that a judgment in the other place, wherever it is necessary. The second thing is to note, although obviously I have on board my Lord Justice Arnold's points about patent peace, but just to note 488 and 496, that in the main judgment, where the judge did say his approach was going to be one of seeking patent peace. And that was, as I understand it, common ground between the parties. Because when I read the supplemental bundles, I read Optis witnesses saying that there couldn't be a crawlback mechanism, was mooted for Apple at some stage, because of the need for patent peace. And at 503 to 505, the judge uses the term closing out the arguments, shutting down the open positions completely. So the judge is seeking to get to something which is a license where on which the parties can operate going forward. Now, the consequential judgment in Core 2 it has two sections which deal with Optis points, which were there at the time. He deals with it from two perspectives. There's Optis argument, which now has rather morphed in Mr. Speck's elegant submissions, because what they said before the judge was that either the judge, we understood them to say in any event, and the judge also understood them, but I think that there's an issue obviously on their skeleton they make about this, but that they were trying to, one of the things they were trying to do was to carve out from the license the US patents. They say they weren't, but that was perhaps not wholly clear to those who were present at the time. The second thing they were trying to do was to carve out from the license the US judgment. And that's what the judge deals with the first in paragraphs 80 to 83. And so this is page 46 of the bundle. And for obvious reasons, I'll take this at a fair lick. But 80, so contending the brand license is one that's worldwide except for the EDTX patents, not open, because the scope in 81 Roman 1 is worldwide. Secondly, if your lordships go to it in later on in Roman 1, at the top of page 46, the correct cross-reference there, which wasn't correct, is 73 2A, but I don't rely on it just in case your lordships got frustrated trying to find it. In 2, he stresses the fact that Optis had carriage of both sets of proceedings. To that extent, this is an unusual case, because normally what happens is one party sues in one place, the other party sues in the other place. And then there's a bust-up, which I often would go along to, about forum conveniens and lis alibi pendens and so forth. But Optis had the carriage of both sets of proceedings. And so they could have asserted what they want to assert in either or both of those proceedings. But in 3, the court has not considered whether a FRAND licence, more geographically more narrowly framed, might or might not be FRAND. Likewise, it hasn't considered whether, as part of the FRAND examination, whether a license which is worldwide but says that implicitly at least, that the Texas proceedings will continue, is FRAND or not. And my addition, of course. In 3A, necessarily, the last sentence, the Optis portfolio is valued on a worldwide basis. 3B, he says he can't reopen the entire proceedings. And then there's a cross-reference again to an earlier paragraph in 3C. That reference should be to 62, Roman 1. And he says that he's valued the stack on a particular basis, and there's more detail given at 62 Roman 1. And so the Apple is buying access to the standard on a worldwide basis by way of a license. It's not a license to discrete sets. 82, so he concludes, he will declare that there will be a worldwide license. And then the alternative case is, he says, first of all, 84, the consequences outlined in the judgments seem to hold good. And then this court should, in 85, second half of it, should declare a license. So the second argument is that this court should declare a license to FRAND terms and leave it to the courts of the United States to work out the implications. I say there that just the sheer phrasing of that, which was Optis phrasing, is redolent of an approach which is steeped in comity. Only appropriate when you're seeking to, is the court going to give a declaration? Is it going to give an injunction or whatever else? But in this context, we say not appropriate, and the judge has found that at 75 to 76. And in 86, so it's a self-denying ordinance, and this really takes us back. I'll just finish this. So 86.1, it's a mistake to regard it as other than a remedy. And then in 86.2, halfway down, the court determined license just that, a set of obligations imposed on the parties pursuant to the jurisdiction I've described. And then he goes on to the point about the court policing role. I should show your lordship 75 to 76.
Why is it a set of obligations imposed on the parties? Because you made the point at the outset of your submissions. This is a contract. So all the court is doing is spelling out the consequences of the contract that's been entered into.
Indeed, my lord, construing the contract, construing and then applying the contract. Indeed, the word imposed, I need to look back because one of my colleagues, learned friends, made the point that I had used the word impose when I opened, but just for 1 o'clock. That was a Freudian slip. I did notice, though, in my defence, it does appear in paragraph 90 of the Supreme Court. But really, the mechanism, what is going on, I think it might have been put rather better by the US Appellate Court judge when she spoke about it. It's construing and applying the contract.
Yeah.
So, with respect, my Lord, I would wholly adopt your point. And that's the word imposed, again, one of the infelicities in the judgment, which we don't shrink from. They are there. And the judge, anyway, I won't say any more. But 75 to 76, because those are important. In 75, Optis stressed questions of comity, and 76, in general terms...
Where are you reading from?
I'm sorry, my Lord. Page 43, paragraph 76.
Oh, I see.
So the judge accepts the comity points, the points regards res judicata, the importance of comity. I regard these points as irrelevant to the question at hand. We say exactly right on UPSC. There's no doubt that Optis and Apple acting in concert can dispose of the EDTX proceedings any way they wish. Indeed, even if those proceedings were concluded with Apple actually paying $300 million to Optis in damages, there would be nothing to prevent Optis from repaying that amount to Apple if it chose to do so. So if we can just revert to my mining example, had there been proceedings both not only in the United Kingdom, but also proceedings by the Australian mine owner in Australia, and then the parties are litigating also in London, and the A, in my example, is saying that these are exclusive jurisdiction, and then the parties settle those proceedings. And they also settle the Australian proceedings. And so an order comes down, the parties agree that both parties will apply jointly to the Australian court for dismissal of those proceedings. There's nothing comity related about that. And we say that's exactly the point. The point is the EDTX proceedings, I continue halfway down, as is the case with civil proceedings generally, can be disposed of by the parties according to their will. The courts across this jurisdiction, the US, will give effect to the will of the parties. Questions of comity, res judicata, competing judgments, and rival jurisdictions, trading on each other's toes in violation of international comity, simply do not arise. And that's echoed, for example, in our skeleton, one of the late footnotes, we cite the Supreme Court case of Enker, which is all about a jurisdiction, an arbitration clause in a contract. And the court said there that comity has little, if any, role to play when you're talking about enforcing contracts. And that's why, when we come on to this anti-suit jurisdiction, that's why there's nothing shocking about a court saying, well, you agreed to settle your dispute with the English court, as did the parties here, we say. There's nothing shocking about the parties being held to that bargain. So that's the basic structure of what the judge found. I should just go to, I need also to go to, while I'm in this judgment, I need to go to paragraph 91. So after considering the alternative case of Optis, the judge then went on to consider a point which he didn't actually decide, which was whether he could, if necessary, take up the pen and sign in Optis' stead. He doesn't decide it. And there were detailed submissions by Optis, I think in August or September 23 about this. But then 91. So he says he's not determined the question. And then about 6 lines down, he starts a sentence. The problem with the undertaking offered by Optis and accepted by the court is that it leaves a gap between this judgment on consequential matters and the point in time at which Optis, in fact, accepts, I think he means signs, the licence. And it leaves that gap, as he says, unpoliced. And so that's the second point, really, because in the sense that without protection of this court, both parties are at liberty to act in a manner that is inconsistent with the terms of the licence that I've declared. Optis is not entitled, absent strong grounds, to an automatic stay, a stay of execution of the court's judgment for a court to determine licence is by no means automatic in our courts. And Apple most certainly are entitled to some protection from the otherwise uninhibited ability in Optis to pursue the EDTX proceedings. To take the most potent example, the solution I've adopted, instead of obliging Optis to sign up to the friend licence now, is to incorporate sufficient protection for Apple in the order consequential in the judgment below. Now, just while in the judgment, I should just go to 72 to draw your attention to that point on acting inconsistently. So paragraph 72 is back on page 37. And the judge just states the nature of the problem in the last sentence, the last two sentences of 72. Because he talks about the fact he was aware of these proceedings. It ought to have been drawn to the court's attention and relationship clarified well before trial, not after it. The problem that's now arisen, and this is important, my lords, is that Optis wishes to take inconsistent positions in the two sets of proceedings. We say that's because of the very nature of proceedings which are for infringement of US patents in the US and for a license in respect to those same patents in the UK, which will expunge, probably the wrong word, I'm sorry, among patent lawyers, but expunge or release the infringements which have already occurred in the States. So that's the judgment. Now, Optis criticisms, they have moved on a bit. I think still in their skeleton, it's very much, they invoke the value of the US judgment. And I can go through a few, I'm not going to turn them up, but in their skeleton, they have a number of statements. 71B, the real world cross-check, 159, including benefits of clear material value, not factored into valuation. 179, the judge should have made appropriate provision to give effect to value in the US judgment. And 180, proper account of the US judgment, not set it at naught. That begs the question of how much. How much is a judgment subject to appeal? How much is that worth? And 211, plaintiffs would plainly give at least value to the judgment and not abandon it. In that context, that can only mean face value of a judgment subject to appeal. And but the one paragraph I would like to turn up, my lord, is paragraph 215 in Core 1, Optis skeleton, which the question, they say 114 in 114 in Core 1, internal page 69 of the skeleton document, the question which the judge should have asked and answered is exactly how, in the specific factual circumstances of this case, willing parties would have taken account of the binding US judgment and the possibility of appeals. Of course, in order for the judge to do that, the issue would have to be identified as an issue for him to determine. It wasn't, but if it were to be determined, there must be evidence on that. Otherwise, the default is both parties are going for a single global determination in the English courts.
Can I be clear? Do you agree or disagree that that's an appropriate question for the court to ask itself? I appreciate you then going on to make submissions about where you go from there, but I wasn't clear whether you dispute that that's an appropriate question.
It would have been an appropriate question, my lord, had one or other party relied on the US judgment on the issue of value before the English court. So had the US court granted $5 million in damages for infringement for 18 months, Optis may well be standing here, Apple may well be standing here and saying to the trial judge, these patents are not worth very much. Look what the US jury gave them. As it is, it's Optis who wants to assert that having said constantly through these proceedings that
I appreciate the point you're making with commendable realism is that as it turns out it's Optis wanting to make the point, whereas it might have been had the boot on the other foot Apple, and that's very realistic, but it doesn't help me much as to what you say the correct way forward would have been without 2020 hindsight.
Well, no, it's not 2020 hindsight with respect. We say that paragraph 64, 65 of the Supreme Court in Unwired Planet give a clear push in the direction of you've got to raise this with the trial judge.
Yes, but you seem to be accepting that neither party did. So at the moment, I understand you to be accepting that this is a perfectly valid question. The court to ask itself, but you say, but neither party raised it, which on one level at any rate is correct. And then the question is, well, what's the consequence that flows from that? in your
Well,
submission?
well, we say the straightforward submission is that if you want to rely on proceedings ongoing in another court, then you would have to rely on that before the trial judge, so that the judge could take a view on whether it's appropriate for those proceedings, for issues in those proceedings to be determined.
It's obviously my fault for asking poorly articulated questions. So let me try and articulate my question in a completely different way.
I'm sure it's not.
Is the point you're making any more than a very simple one? Namely, there was a time and a place to raise, for Optis to raise the point, they didn't, and it's now too late.
That's it, my lord.
Right. Okay. Thank you.
But is the difficulty that arises out of that it's not too late because there is no license settled yet, and the question of what to do about these the question of what to do about Texas is unavoidable when you settle the terms of the license. You have to do something. Even nothing is something.
Well, indeed, my lord, that's yes. Because my own friend says, "Well, do nothing," and that's all very well. But in fact, doing nothing is something.
Exactly.
Because those proceedings are
that's
there.
My point. So how does it help to say? I mean, how does it help to say, well, it wasn't raised, if in fact it's the light of the tunnel, which is in fact the oncoming train. If you do nothing, it will still hit you.
Well, indeed, my lord, but it's. Sorry? Yes, I mean the parties came to this court, an agreed position, a single global license determination, which would include, and it's common ground, that there was to be a release for any infringements elsewhere.
But that's the crucial point, though, isn't it?
It is.
That's the crucial point. Your case is it's common ground. There wasn't nothing. There was something, and it worked in a particular way.
Yes. Then the fourth point was just to note that in terms of the evidence, you have the submissions in our skeleton at 239. And there are examples there of the evidence which would have been called had this been raised. And their case is effectively, their case before this court, as set out in the skeleton, is that the licensor or licensee would self-evidently not include any term regarding US proceedings. But whether or not, it's really the point that my Lord Justice Birss has just put to me, that even if you do nothing in the license, that is doing something.
So just to be clear, you say that if this point had been live below, you would have called, or might have called, additional evidence.
Indeed, my Lord.
And that's what you're addressing in 239.
Indeed, my Lord, and in fact, perhaps I shouldn't have jumped over that, because when one looks at it, it's quite a lot in blue, but it's particularly if your Lordships look at the last sentence in the blue on page 216.
I'm obviously in the wrong place. Can you give me the reference?
Sorry, page 216 in call 1, my Lord. It's in our skeleton, so Apple skeleton 239.
I mean, I can see potentially it's not a point to jump over, because this court isn't overly keen on letting in points for the first time if proceedings below might have been different.
Yes. It will indeed. And so the first category is evidence of those involved in licensing negotiations, and you'll note at the bottom of page 216, the last sentence, similarly, an unnamed party, a party I won't name in any event, included a full pass release as well as provision for dismissal of litigation in circumstances, where there was another court judgment for a number on a single patent, which was under appeal at the time that the license was concluded. And there's a cross-reference there, and there's a small amount of evidence given by Miss Muse on this.
And then you refer to a economist, a valuation expert. Then you say evidence as to the prospects of the US judgment being set aside. But why would that have mattered?
Well, I mean, of course, in a sense, it's always a trial within a trial. I mean, one would have had to answer the question, well, these US proceedings are ongoing, there's an appeal, so the way that Optis pushed in their skeleton was you'd have to value them. And if you're valuing them, that would certainly come in. But the similar sorts of evidence, apart from that, possibly that last one, is necessary whether you determine as trial judge that the overseas proceedings will continue, or that similar sorts of issues would come up on the issue of, is it appropriate that the issues in relation to these patents should be determined somewhere else? The example given is, for example, particular patents are particularly important for the portfolio. Given the damages awarded here, possibly that might be the case for these patents. Might well be. But if that is the case, then that's a judgment for the court to make, we say, and not, as Mr. Speck would have your lordships agree, that it is a choice for the parties. Now, my next topic is in paragraph, the next topic is the fifth topic, that Optis relied on various exchanges after trial. I won't go to them because you were taken to them by Mr. Speck, but essentially the way in which this point arose was that Optis reply closing sought at 292 to reserve the relationship between EDTX and the UK until after the license was determined. And Apple read that and thought, aye, what's coming down the line? And so they wrote back in 11th November 2022, I won't go to it because there's just not time, subcall tab 15 197, saying, and my friend went to it, saying that this is Optis' proposal, which I've just referred to, was new and controversial, not pleaded, and Optis' submission may well require submissions after judgment. That was about Optis' submission about reserving the relationship after judgment. And then Optis come back saying, well, we just gave an example. Carving out the US patents is one way you might do it. But any agreement which Mr. Speck was asserting was made is by reference to Apple's letter of the 11th of November. And there's a reference in our letter of the 1st of December, which is subcall tab 17 199, to dealing with double recovery rising out of the ETX after judgment. But that's not rowing back from Apple's position, the primary position, which was that on the pleadings, Apple was seeking an express dismissal for the EDTX proceedings. And so the 1st of December letter was concerned with the matter of netting off after the event. There's a rather discrete point which I need to deal with under ground 23, which arises from Optis' skeleton at 213C. And this is that Optis argues that the usual nature of FRAND license requires the US judgment to be taken into account, the Optis argues the usual nature of the FRAND license requires to take into account the existence of a more limited license in the US judgments covering part of the portfolio, because they argue that this was done for the ex-Ericsson patents. There are three short points on that. The first is that the judge excluded the ex-Ericsson patent families covered by the original and the new arrangements. And the main judgment of 491 relied on the fact that Apple already had an arrangement with Ericsson, and so it was wrong to require a second license. But we would answer that. The US proceedings in this case may or may not result in a licence going forward. Because Optis' preferred option, it seems, is that to reinstate the 506 million. Mr. Moss in 35 says, well, we are instructed that we won't be applying for any royalty for the future. That says maybe. We'll see whether that occurs in the United States or not. And secondly, the ex-Ericsson patents include complete families. And this is important, my lords, because my own friend has been saying all the way through that, we can just treat the US patents as if they are complete families, but that was not before the judge. The judge had to decide it on the basis these were 5 US patents, and valuation or the infringement proceedings for 5 US patents. And so it wasn't wrong for the judge to consider the matter on the basis of the facts actually before him. And one final point on this is that the ex-Ericsson patents were in issue at the trial. And in Apple Skeleton, I won't turn it up, 215216, Apple addressed the issue of the ex-Ericsson patents on the basis that it was a question of the subject matter to be covered by the FRAND license determined by the court. They were not contradicted in that by Optis. So that's the ground 23 point, Lord. Essentially, the judge found that there was an overlap between 2 sets of proceedings, and he found that Optis failed to address the overlap until it was too late. And in our respectful submission, the judge's treatment of the US judgment was wholly in accordance with the material put before him and the submissions made, and there was no error of principle. And so we don't address the imaginative ways in which Optis envisages at paragraph 220 of that skeleton and following of ways to adjust the licence to take account of the US judgment. Ground 22, I can take relatively shortly. This is about alleged unfairness in relation to paragraph 6.2 of the final order, the way in which it was made. And there are 3 factual premises to this argument. The first is that it's in 177 of the Optis skeleton that Optis had no opportunity to address the merits of the proposed order. The second factual premise is that the order, as made by the judge, was not sought by either party. That's also in 177. And the third premise is that the obligation not to act inconsistently was not the subject of submissions in either July or December, and that's Optis skeleton 141C. Each of the premises is incorrect on the facts. The judge suggested, the first is that the judge suggested that he suggested this obligation not to act inconsistently in the December hearing. We should turn that up, Lords. It's in Sup 1, tab 24 at 415. This is where we find the origins of the Baroque and Rococo, but anyway, that's by the by. So page 415, because there were complaints. Basically, the problem with the license was that when it came to determine the license, as far as Apple was concerned, Optis was saying, well, it's much too complicated, much too complicated. No, it's much too simple, much too simple. Is the sort of the broad overview. But I pick it up in the transcript at page 168 at the bottom. And so where the judge muses aloud, I wonder whether, at line 18, I wonder whether it's better, not better, therefore, to remove the Baroque and just to articulate the plainest of language what these clauses are getting at, just so that one can identify how objectionable they are. And then he puts a suggestion. Optis promises not to act inconsistently with the judgment under case for US proceedings. 2, to take all steps to ensure the efficacy of that judgment in which the SEPs are being, the subject of litigation, in any jurisdiction in which the SEPs, the subject of litigation, are being litigated. And so,
I've lost the reference.
I'm sorry, my lord, page 415 in Sup 1.
Yeah.
Tab 24. It's on the bottom left tile.
Thank you.
Yes, and so at the bottom, the wording is floated right at the bottom, line 25, going over to page 169 in the tile, and the case number HP 22019-006 is the EDTX proceedings.
No, it's this case.
I'm sorry.
It's the English
I'm sorry. It's the English case. I'm sorry. I'm misunderstanding my notes. I'm sorry. Of course, I'm sorry. Yeah.
This is musing about terms in the licence, isn't it?
It is. Well, it's at this stage, my lord. Coming up to the. There was some movement about of clauses between the order and the licence. But although this appeared in the licence, although it appeared, I think it might have even appeared in a draft of the licence, both parties were agreed that if this appeared, it ought to appear in the order, because it's about holding the ring. It's not about the definitive position. I mean, Mr. Speck may want to check that, but
No, you check it. You check it.
no, I think, I mean, from recollection, that there were at least one, and I think this might well have been it, which moved from the draft licence, the judge's draft licence, to the draft order. That would be in the February correspondence. And so at line 12 on page 169, the judge says it's inelegant drafting, it's trying to strip down along the wording. Interested in what both sides have to say about drafting along those lines. And then at 417, Mr. Bloch comes back to this on the bottom left-hand tile, 194, line 14. He's dealing with this provision which the judge has suggested. The points I make in relation to that are, first, one has to define the basic terms that should be protected first, hence why one has to have in the agreement that all proceedings shall cease. Secondly, that my lord may well, in the way which you set it out yesterday, have captured the essence of what the parties are seeking. So doing what any good advocate does, if he thinks that it might be in his interest, he's got something there which he can live with, and indeed he talks, 195, Mr. Bloch, still line 7, we need some protection, and then that goes over to, and then Mr. Raphael then deals with this in line, page 419, he makes submissions on this proposal. So it's bottom left-hand tile on page 419, page 210 of the transcript. The court proposes a contractual term, not discreet, not inconsistent with the judgment, take all steps to ensure its efficacy. Against that, you see what Apple actually seek. Comparison makes the points, not workable or appropriate. And he carries on. But what's abundantly clear is that it was the subject of submissions. It was a proto clause which was not in exactly the same terms by any means as what came into the February draft order, but that's the way it was. And so standing back, Apple were definitely seeking some protection against having to pay both UK and US judgment, given the terms of the CDL as determined by the judge. And 6.2 is essentially a mechanism alighted on by the judge, but then adopted by Apple. And so we say that there's no unfairness. And on the binding guide point, my learned friend referred to this as part of ground 22. In fact, it's not in ground 22, it's in a different ground, but I just refer your lordships to paragraph 200 of our skeleton. The essence is the judge made abundantly clear on the transcript he was listening, that he had not determined the points on the US judgment against Optis. In the consequentials was determining, and indeed heard for 5 days, it's 5 to 6 days of hearings on consequentials. So I turn then to ground 24, and I'm conscious that we're coming towards the end of our time. On this, I think we need to look first of all, my roadmap is the nature of Optis objection, brief response to Mr. Speck on facts, relevant findings in the judgment, which I think I've really done, and we started also on the meaning of the order, so I can take that perhaps more quickly. The basis in law, and we'll be saying it's a FRAND process obligation or protecting the integrity of the judgment. and the conclusion. So, first of all, the nature of the objections is apparent from their skeleton 244, where they say that this point, that is ground 24, is moot if the court-determined licence is varied to a proper form. It's a realistic approach for a friend licensor who has given an undertaking to enter into the friend licence, considering in particular that the previous undertakings Optis had given, and considering in particular that licensors in other cases have voluntarily accepted more extensive obligations than Optis has in fact accepted here. I refer there to Unwired Planet and IDC and Lenovo. In this case, I've already referred in passing to the 3rd of August 2023 order. I'll give your lordships a reference, but I'm not going to go to it. It's Sup 5, tab 3, page 9. That was the order where Optis' undertaking to the court was recorded, and also there are various undertakings in quite long recitals about not divesting itself of patents, not letting the patents lapse, to request extension of the briefing schedule from the CFC, and to commence and not to commence any new proceedings inconsistent with the Friend licence. So Optis accepted obligations which it at least tacitly accepts could be inconsistent with their undertaking, we would say, things like divestment or letting patents lapse. In the case law, one sees, perhaps I think I could risk turning this up, in the authorities, bundle 3, at tab 11, there's a judgment on costs of Mr. Justice Carr, Henry Carr. So, tab 10, I'm sorry. It's tab 10. Sorry, I'm corrected, it's tab 10, otherwise, I'm sorry. It's the Henry Carr one, yes. Yes, I'm grateful to know from Mr. Speck. So, I turn to page, yes, paragraph 11 on page 452. So, I've mentioned, says Mr. Justice Carr, that Huawei gave an undertaking to abide by the terms of the settled licence as if it was in full force and effect. No such parallel or mirror undertaking was asked for or offered by Unwired Planet. No doubt that Mr. Justice Birss did not anticipate that Unwired Planet would behave otherwise than if the licence was in full force and effect, having been the person to ask for it in the first place. However, 11 days after the form of order hearing in the UK, Unwired Planet commenced new infringement proceedings against Huawei in Mexico in relation to 2 of the equivalent patents. Mexico appears to have been chosen because of the availability of rapid interim injunctive relief, and indeed, Unwired Planet immediately sought such relief. Unwired Planet sought preliminary injunctive relief against Huawei in Mexico. And basically, the judge takes a very dim view of this. Unwired Planet, I mean, it's taken into account on the issue of costs. And there are different issues of costs, I'm not going into those. But it's the expectation of the judge that this is simply normal. This is what you've signed up to. And you shouldn't be going off to other places. And of course, the more recent judgments shed more light on this. There's a similar reference in IDC and Lenovo, which I won't turn up, in Authorities 2, tab 2 at 81, paragraph 109, where I think it was Mr. Justice Mead.
Mellon.
Oh, I'm sorry, Mellon, that's yes. That save for particular clauses requiring irrevocable steps, both parties undertake to treat the licence as if it's in force pending appeals. So we say that this is not a surprising provision. On the facts, just to correct 2 matters asserted by Optis, Learned Friend said that there's no basis for any relief to hold the ring, as Optis indicated, that it would not wish to cause any irrevocable step to occur. And whilst initially correct that Optis had agreed to stay in the United States, that's on the 4th of December 2023, which is Sup 5, 26, tab 26, 89, Optis announced proactively it wished to restart the Texas proceedings, that shortly before the second consequentials hearing. This created a race to judgment. The race was real because Optis' position in the December 23 hearing was that Optis was entitled to recover whatever the UK and the US courts awarded according to their rules, even if for the same patents. And Mr. Raphael, King's Counsel, argued that this was not what he called double dipping. which sounds to me like a nice way of saying it was not double recovery. But it didn't convince us. This was on the basis that the judge had to consider matters. This was the legal argument on the basis of which this was made was of Mr. Shesby in paragraph 38 of his witness statement in, I think, sub 3, tab 1. And Optis did entertain the possibility of escrow for the US judgment monies so as to put out of reach the jeopardy, but that was withdrawn by Mr. Raphael. Immediately Apple confirmed that it was not applying for an anti-suit injunction. And so that, we say that's inconsistent with Mr. Speck's assertion, because had Optis been wanting to avoid any irrevocable step harming Apple, it could have progressed the US proceedings but entered into an escrow arrangement. So we say Mr. Speck's factual submission is factually incorrect. And Mr. Speck also asserted that they could take no step in the US proceedings without asking the English court. I've dealt with that. So, my Lord, I've been through other parts of judgment, my Lord. The basis of relief is the Fran process obligation, paragraph 21 of Panasonic, drawn from paragraph 64 of UPSC, or the broader relief, the protecting the integrity of the court. The broad idea is in the bundle. We cite it in our skeleton argument. Broad idea was a freezing injunction case. Various of the anti-suit injunction cases are cited. Paragraph 85 is critical. The essential purpose of a freezing injunction is to facilitate the enforcement of judgment or order for a sum of money by preventing dissipation of assets within the jurisdiction, which would defeat the judgment. So while it's also right that protecting the jurisdiction of the court is a sufficient ground for an anti-suit, we say that this is not, in fact, in its terms, it's not an anti-suit. It is, as the judge described it, a form of monitoring, so that the court can examine what's going on, and if the need arises, potentially grant an anti-suit if a party applies for it. And as yet, neither party has, and so that's the current position.
But, sorry, if
Yes.
all the judge is doing is leaving it open to parties to apply for an ASI if advised, why is any court monitoring required?
So that there would be some notice of this, my Lord. So it's in the form of sometimes other orders have put a requirement that a party, before taking a particular step, must give a certain number of days' notice to enable a party to go off to the court. I'm not saying that this is 6-2, I'm not saying it's perfect, I'm saying it's defensible in the circumstances. I'm saying that the undertaking of Optis effectively required it not to do anything inconsistent with the final judgment. But of course, defining what is inconsistent is difficult. Your Lordships may feel, at the end of this appeal, if I've been successful on ground 23, that you prefer to substitute a different form of holding the ring relief. And we can argue about that at the time, if that were the court's preference. But it's some form of relief was what Apple was seeking at the time. And on the anti-enforcement point, your Lordships were taken to the SAS case, and there was a long quotation there from Lord Justice Clark's judgment in Ecobank, Authorities 1, tab 8. The paragraph immediately before the citation in SAS, so 117 in the judgment of Ecobank, we think is particularly important because Sir Christopher Clark makes clear that anti-suit style relief, or any relief in respect of foreign proceedings, is much more likely where you've got a judgment of a foreign court, but you've got an agreement after the event. After that judgment, which is when the undertakings in this case were given, both undertakings in 23, the judgment in the US was in 21. And then so that I think that's all I need on that. The terms of 6.2 are designed to hold the ring, and you could take your own view. Now, Lord, I've run over what I was supposed to do. I don't know whether your lordships are necessarily going to rise on the dot of 4:15, or whether you might be able to give us 5 minutes, because my own friend did go on 10 minutes longer on a couple of days.
So be clear, you'd like another 5 minutes.
5 minutes for Mr. For,
For Mr. Turner.
Mr. Turner, just to come back on points, if it were possible. But it's in your lordship's hands.
I think we're content with that. Mr. Turner, if you want another 5 minutes, you can have another 5 minutes.
Well, this is very short. This is not coming back on anything. This is the thing that I said at the beginning that I would cover if there was time, but I can do it in writing if the court prefers, which is that my Lord Justice Arnold asked us some questions about what had happened in the trial in relation to the experts and the way that they were treated. And I've got some notes here which should take approximately 2 minutes, 15 seconds.
Let's try the 2 minutes, 15 seconds.
To deliver. Have a go. So question number one was, did the experts say why they were favouring, respectively, the dollar per unit approach or the ad valorem approach over the other structure? And my lord asked me, and were they cross-examined about that? Well, Miss Guttridge said she was expressing the royalty rates on the dollar per unit basis consistent with Apple's pleading, which is something I think I showed you on, or told you about on Friday. I can give you the reference if you want. She did present also, as she drew to my attention, some ad valorem rates in the appendices to her report. And it's fair to say she also drew on certain other evidence, economic and factual, to make the proposition that ad valorem may overstate the value of cellular technology in a premium phone. On the other side, Mr. Bizant referred to the fact that ad valorem rates are commonly used in cellular set licenses. He pointed out sometimes with a cap. He, as far as we can discern, didn't give reasons why ad valorem was to be preferred as an approach to DPU, in the same way that Miss Guttridge didn't do the reverse. And then, given the absence of positive reasons for selecting one methodology rather than another one, there was little cross-examination by either side of the experts' reasons. Why did you choose this, not that? On that, if an expert hasn't given reasons in their report, the court will understand that a well-advised cross-examiner will not often provide them with a platform to give reasons for the first time orally. Having said that, and to remind the court, the judge sets out in the judgment a very long piece of cross-examination by Mr. Speck of Miss Guttridge, which he says illustrates what he perceives to be the omission of the expert to consider a number of basic questions about brand. And just to give you the reference, that's in the judgment. It spans pages 393 to 396, and it's under 314 Roman 2. And last, was it put to the experts, my lord asked, that they'd strayed impermissibly outside their expertise? We haven't seen such criticisms from our review of the cross-examination. On the contrary, particularly in the case of Miss Guttridge, it was noted at various points that for her to opine on certain issues, for example, what data do you use to assess the size and strength of portfolios, patent portfolios, and so on, it was said, well, that's not within your expertise. The judge did then comment at the conclusion of the oral closings about how difficult it is to discern the boundaries in a case like this between the various expert disciplines. He did note that the experts had ventured into technical matters and technical experts had gone into matters of value. And the reference for your lordships is Sup 1, 21, page 370. But he did make clear that he considered that the experts' conduct was entirely proper. And that is consistent with what's in the main judgment, paragraph 316, where the judge says there's no criticism of either expert. And lastly, I think the final question from my lord was, did either expert opine on the issue of which license or license was the most comparable? Answer, yes, based on specific characteristics of license X. So you will have seen when I took you to it, for example, that Miss Guttridge identifies a certain number of Apple licenses as being of particular interest within the group to her assessment. And equally in his report, his first report, Mr. Bizant says, all else equal, I'd place more weight on running royalty over lump sum because they're more straightforward to interpret. of the lump sum licenses, he would place the most weight on Google. And in principle and in isolation of other factors, more weight should be placed on comparable licenses for the IP at issue. Matters of that kind. So, my lords, I hope that's sufficient. That's my 2 minutes and 15 seconds.
Thank you very much. Mr. Speck.
Seems a very long time ago, but on Thursday afternoon, my learned friend sought to suggest that the answer to my submission that the judge got into a muddle as regards the use of lump sums as an approach to valuation was that really he meant DPU where he said lump sum. That was an untenable contention in my submission, and all I will add is this. That is why we both sought to correct the judge in the way you've seen in that black, blue and green document leading to his infamous footnote 59. If my friend was right, we should simply have been telling the judge that he'd mistyped lump sum and it ought to be replaced by DPU in the effective places. And we didn't do that because that's not what was going on. Mr. Turner made a similar attempt to suggest that when the judge referred to insurmountable issues with the unpacking, in particular because of the three subjectivities, he didn't really mean that either. Recognising that the judge did indeed go on and deal with the same points himself, Mr. Turner was in a difficult position, and he sought to suggest that the judge really meant the issues were unavoidable rather than insurmountable. Again, in my submission, untenable. That's not what the judge said, nor would the judge's criticisms of the expert approach have made any sense if that's what he meant. My lords will recall that was part of the judgment where we first identified other issues he thought were problems with their approach and evidence, but thought they could have been addressed and therefore were surmountable. And he was specifically going on to make the point that his three subjectivities were a greater problem because they were insurmountable. Now, my lords, my learned friend also sought to defend the judge's rejection of the expert's approaches. This is a submission he made just after lunch on Friday, where he suggested that the judge was justified in rejecting all the expert evidence rather than resolving such differences as there was between them. And the thrust of the argument was that he was justified in doing this because they hadn't engaged with each other's evidence and approach. That was an extraordinary submission, but it's absolutely crucial to my friend and his overall case. And let me be absolutely clear why it's crucial to his case. My friend has to defend the judge throwing out the expert evidence and approach in toto. If he can't do that, he fails at the first hurdle in seeking to support the judge going down the route of his own method. And as I shall come on to, he desperately needs to do that, even if all the individual errors in the judge's method that we've identified are corrected, because it restricts consideration to the value that you get from the judge's method, which is an averaging of a group of licenses heavily affected by Apple's holdout conduct. And that's why it's so important to my friend. I'll have more to say about that shortly, but he desperately wants my lords to be looking at fixing the judge rather than thinking the judge shouldn't have gone down that route at all. And what is it that he suggests to justify jettisoning all of it, including those common underlying principles that I identified? It's a suggestion that it's because the experts did not engage with each other. And he says because of that, the judge could simply reject it all and not seek to resolve what differences that there were. Now, my Lord Justice Birss asked him at one point if he accepted the judge was entitled to reject his own expert's evidence. And he obviously had to answer yes. An uncomfortable submission to be making about one's own expert. Be under no misapprehension, this submission is one that his own expert, and in fact his own side, more widely, were completely remiss in how they went about advancing their case. My Lord could have gone on and asked him an even more uncomfortable question, whether he also accepted that his own expert evidence went beyond her area of expertise, as the judge had accused her and Mr. Besant of doing, or whether he accepted that she simply rigidly followed Wilmer Howe's instructions. None of those would have been comfortable questions for my friend to answer, all of which are wrapped up in this issue as to whether or not the judge was entitled to reject the evidence and approach of the experts in toto. And it's just not right, in my submission, that they didn't engage with each other. And in fact, it's actually quite a serious allegation to make against professional witnesses. One wonders why it was we had several further rounds of reports from them after the initial exchange of evidence with position statements. And we saw, as an illustration of how my friend got this wrong, with his suggestion as to how the experts approached their unpacking, with the suggestion that Miss Guttridge was stuck in the DPU lane and Mr. Bazant in the ad valorem lane. Fortunately, Miss Guttridge was watching remotely, and what she had done was corrected by him after, I think, the shorter German. I wasn't sure whether he actually got Mr. Bazant's activities correct, because I thought at one point he was suggesting he only did ad valorem. What he was doing was muddling up another dimension with this, which is the fact that they didn't all do the three bases of unpacking that Mr. Bazant did. My lords will remember free release, simple and adjusted. Miss Guttridge only did free release, but of course the DPU AV dichotomy is a separate dimension to all of this. And in fact, as I think I explained to my lords when I was doing my address, Mr. Bazant initially did AV, but then in a subsequent report, I think it was his fifth, he did DPU for his free release to be able to compare with Miss Guttridge and on her DPU unpackings. And as I explained also, I think, that in closing, all three were provided in our Annex 5 to our closing. I just want to remind you of that, if I may. It's supplementary 1, tab 5, page 117. It goes on, you don't need to look at all of it. But what I want to remind you is that Mr. Bazant, all three of Mr. Bazant's bases are there in AV and DPU. And Miss Guttridge's free release are there in AV and DPU. It's the last column for Miss Guttridge and the penultimate column for Mr. Bazant. And of course, as I showed you in opening, the differences between them were in general pretty minor. A particular exception was the dispute of on the Ericsson unpacking. But they were there. And perhaps at this point in the argument, I need to say no more than this. What is that if it's not engaging with each other? Another point my friend made was seeking to suggest that the judge didn't see the lump sum approach and the ad valorem unit price approach as distinct. Now, Mr. Turner has to put it that way because if he did, it's an obvious and serious fundamental error. So he has to argue not that it's not an error, but the judge didn't do it. The truth of the matter is that he plainly did, my lords, and I'll just give you a reference, given the time, to what he said about his approach in the consequentials judgment. Please read, when it's convenient for you, paragraphs 11 to 14, that's in Core 2, tab 1, where the judge plainly is identifying these as mutually exclusive alternatives, and even saying that lump sum licenses are good for the lump sum approach, but not the ad valorem, and ad valorem is only good for an ad valorem approach. Another argument Mr. Turner sought to advance was that the parties didn't approach matters on the basis that the agreement should be weighted by stack share. Now, what he did there was to show you the comparables approach that was within each party's case, which of course is an approach where you do not combine data, add them up or averaging at all. So he's showing you an example where there wouldn't be any weighting to try to say, well, therefore you didn't have weighting. What I showed, my lords, was in the argument that was addressed by each side in their submissions, the apple pie argument, we did add them up, and the effect of that was to add them up in a way which weighted them by stack share. So it's no answer in my submission to just go to a method which is not combining at all. I think my friend has actually dealt with the next thing I was going to deal with in my note, which is to explain that the experts did also engage, not by identifying the best comparable, then doing the sums and telling the judge what the answer was, but they did engage with the factors that would be relevant to identifying the better comparables before him. Of course, they didn't tell him what the answer was, and it was subject to things like the argument on holdout, which was not for them to decide, but they definitely did explain to the judge the kind of factors that you would be looking at or for to have a particularly good comparable. Now, something I foreshadowed just a few minutes ago is that Mr. Turner was keen on pushing you towards what's been referred to as fixing the judge's own approach. And he's doing that because he still achieves a very major undervalue if that happens. And my Lords will recall he came very close to making a submission that Apple would live with my Lord's own assessment so long as it was within the realm that you see in our tables as outcomes if you correct the judge's approach. Those outcomes are okay for him, but if you're of the view that the correct approach would have been comparables, which would lead to a higher outcome, then actually he requires a retrial instead of that. That was a very noteworthy stance for two reasons. Firstly, because it's so opportunistic, it sounded to us very like a submission that they would accept my Lords carrying out your own assessment if the judge has gone wrong, but only if it remained at that lower price band. And secondly, because in fact the path for my Lords is so very much easier in identifying the best comparable and taking a price from it. The scope of the dispute on the unpacking is limited and well defined. For Google, it's a single point on the number of units to use. I've explained that to my Lords. And if you like, you can err on Apple's side on that. For Qualcomm, there was no significant dispute at all. In fact, my friend suggested that I didn't cross-examine Miss Muse on the Qualcomm hold-up point. I did, just to give you, while we're on Qualcomm, the reference to that. It's Supplemental 1, tab 21, page 350 to 353. It's manuscript pages 960 to 972. But in terms of how you unpacked it, I've explained to my Lords that in fact that both experts came out with an unpacking that was relatively close. Now, why is there this dichotomy? Why is the debate, when one fixes the judge's approach, centering on numbers that are significantly below those you adopt, you come to if you adopt the conventional approach? It's the reason that I've foreshadowed already. It's because it involves sticking with a process that is averaging, even if you weight it by stack share, across a body of licenses, all of which are depressed substantially by holdout. And that's why I explained to my Lords that holdout is an overarching point that bites on the judge's own method too. And it's a quite separate reason why the judge's approach cannot stand, because what you're doing is averaging a group of licenses which have been substantially affected by that feature. Before I address the further argument that my friend adopted to try to save the judge's approach, can I just draw attention to the fact that what my friend did in his submissions on this was to say that it was obviously wrong that a lump sum from Google could be used. And I think he hoped that you would just proceed as if that was a concession and you would start thinking in terms of the judge's approach absent Google. The very fact that part of what the judge did included Google shows just how misconceived the judge's idea of there being flat lump annual fees for access to the standard really is. And what my friend did by making that concession and ignoring the fact that the judge had thought it appropriate to include was to slip the ball through your legs there as to what he had to support and justify on the appeal. He then sought basically to argue that it was all just a simplifying assumption, but it was far from that in my submission. If the judge, for example, had other lump sum licences between whatever parties, other than the minnows, it's obvious he would have thought he should have included that other lump sum as well. And so what my friend was doing, quite skillfully, was to basically, by a form of a concession, was to put himself in a position where he actually had something that he could begin to argue was supportable. And what I say to my lords is that you should not allow yourself to be duped by that. The judge thought that any lump sum other than for minnows was basically all fair game for adding up and working out what a lump sum for access to the standard ought to be. Now, what he then went on to do, which was really the thrust of his argument to support this, is to say that what was going on was not so very different from the Apple framework and was a reaction to the circumstances of the case and the evidence led. And to be absolutely clear, when he said the Apple framework, that is the pleaded framework set out in the pleading and the expert evidence. So it's the calculation of a top stack price using SSPPU, profits available, or just a figure of $5 plucked from the air. And my friend agreed with my Lord Justice Arnold when you sought to formulate his point back to him, as in substance this: although the judge's method was different and his own and not foreshadowed, the building blocks were there and in the evidence of the parties' approach. That he agreed with. My lords, don't be misled into thinking there is anything in the Apple framework or in fact my top-down cross-check other than the existence of an overall stack price. That is it. The most that can be said is that there's one building block, the use of an overall stack price, and it's a small building block at that. But that is all that was lying around that the judge went with in his own method. The rest of it is all new and not part of the Apple framework at all. Can I move on and deal with another topic that my friend addressed, which is holdout? And the way my friend sought to deal with holdout was to advance, I think, three strands of argument. First, and his primary point, was to suggest to my lords that in fact the real negotiations that were going on orally, and in effect the substance of what was seen in the correspondence was all a game being played out, and they took no notice of it. Second, actually, as an aside, he sought to make something of how the interdigital agreement was viewed in another case, suspending his concern about Hollington temporarily, but also, perhaps more importantly, without having regard to the fact that there was no disclosure, let alone cross-examination of the kind we've had here in that other case, to see what was actually going on. That's his primary line of argument. Secondly, he suggested that within the negotiation dynamic, there's an equal and opposite threat of SEP owners seeking to avoid Fran determinations by running off around the world, seeking to exert hold-up pressure. Third and finally, he also sought to say that in this suite of submissions, that when you saw the provision of sets of claim charts, that is sampling in the sense of a method of valuation towards assessing the value of a portfolio. So those, as I understood it, were the 3 points, and can I deal with them each in turn? Before I do so, can I point out that it's completely different to the argument set out in the skeleton. That was an attempt in the skeleton to argue the judge's finding of fact amounted to conduct of a patent review as an entree to negotiating a portfolio, as opposed to engaging in the blueprint for holdout stance of patent by patent. Now the thrust of the argument is actually what was going on was all done unseen in the correspondence orally. What my friend never did, another point that I want to draw attention to, is he never explained why these sophisticated parties were bothered with the written correspondence if it wasn't actually the substance of or even part of their negotiations. Can I just show you one of the letters that he's now suggesting was, well, let me just say a letter that's now not really what's going on in the negotiation, rather than causing further controversy by giving it a characterisation. Can we look in supplementary 2, tab 26. This is Mr. Watrous. And you also need at the same time Miss New's cross-examination on this, which is in Sup 1, tab 21, page 332 of the bundle. And we need page 885 of the manuscript. And the letter starts on page 125 of Sup 2, and I'm actually turning to that at line 4 of page 885 of the transcript. And you see I asked Miss Muse to read the first 2 paragraphs under the heading on page 126 of the bundle, Sup 2 of our bundle. And as I put to her, this is lines 10 to 14, those 2 paragraphs insist that Ericsson must prove each and every patent is infringed, each one must be looked at and withstand challenges to validity and so forth. Miss Muse agrees. I drew attention to the assertion that this is black letter patent law, it's line 15 of the transcript, and I go on at line 18 of the transcript to draw attention to the assertion in the letter just below the bottom hole that that's a SEP owner's burden of proof and it's not optional. Mr. Watrous says it's the law. Line 21, I suggest to her that's strong stuff given it's not the law. She retorts that it was at the time. She's obviously referring to the fact that Unwired Planet hadn't happened at this time. And I actually rely on that, my lords, because it makes this conduct even more pernicious at a point in time when no court in the world had actually said you could get round this. And I also submit, as you know, that it doesn't actually take the Supreme Court identifying it to turn it into something which is in fact the most pernicious blueprint for holdout. My reason for showing you this is that at this point Miss Muse does not say, oh, this is just the parties writing stuff that we all knew was not really part of the negotiation. This is a deadly serious threat in my submission. And as the judge held, what they were doing is saying these things to soften the counterparty up. The finding that my friend just ignored when he sought to argue there was no depressive effect on the price agreed. What is a finding of softening up if it's not that you get them to agree something that they would not otherwise agree, i.e. a lower price? My lords, it's perhaps, I'm not going to take up time now, but it's perhaps worth reading on through that transcript what it is that, all the rest of what she said about that letter. Because that letter is absolutely typical, and it is untenable in my submission to submit to my lords that these people that were writing and receiving these letters weren't taking these things seriously, which is the effect of the submission now. The second strand that he sought to deploy was a suggestion that there was an equal and opposite pressure from SEP owners holding up. Now, you saw the footnote 5 in that Qualcomm case, which illustrated that Qualcomm really wanted a global licence. And I think I detected that it's plain from my Lord Justice Arnold's intervention that you're alive, very alive, to the timing here. That is a letter where Apple refused a global determination as against somebody else, Ericsson. Ericsson wanted it, Apple wanted it patent by patent. And I detected from my Lord's intervention, and indeed from paragraph 15 of last week's Lenovo judgment, that my Lord is well aware that this development in the way in which SEP owners have started to perceive the prospect of a global determination, particularly in the UK courts, is as it were, a development since this judgment. And having heard the argument on this appeal, my lords might have an inkling as to why that shift may have occurred. Suffice to say that there's no basis whatever for considering that kind of dynamic being in play in any of the licenses that we're concerned with. That leaves the last point, which is the point about the claim charts being provided. There is a world of difference between a sampling exercise in the sense that I understand my Lord Justice Arnold to put to my friend, which is where you're taking a set of patents, ideally at random, to get a feel for what the total might be worth. to what goes on where you've got a party saying it's patent by patent licensing, please show me some claim charts to see if I think you've got any at all. And it's quite plain that what was going on was the latter, not the former. Can I move on to the Google license itself? Because on Thursday afternoon, my friend sought to undermine my comparables case built upon the Google license. And I think there were, leaving aside the argument that it didn't quite cover the entirety of the portfolio because it had ex-Ericsson patents in, but apart from that, there were two limbs to his attack. First was to suggest that the Google license wasn't properly or robustly negotiated. The same suggestion was made at trial on all the Optis comparables, but for Google it comprehensively failed. The argument on Thursday focused, like it did below, on a contention that the overall level of payment was comparable to litigation costs, coupled with an argument that the mobile device market was not an important part of Google's business. But the judge considered precisely these contentions and made findings contrary to the contention by Apple. Make no mistakes, my lord, the suggestion my learned friend made is a full frontal attempt to attack the judge's findings of fact to the contrary, without it even being raised in a respondent's notice. The second point made by reference to the Google license was to point to what it translated to as a total stack price, assuming, he suggested, being generous to me, that it was a price paid for 1% of the stack. And there was some muddling up in comparing apples with oranges in what he did thereafter. The correct cross-check is the one I showed you, which is in the judgment, showing a fraction about 3 times that it might be reasonable for the total stack to be, which I explained can easily be accommodated by the uncertainties as to the error of the stack share in play. In fact, it's really important that my lords understand that, when looking at that, is the overall price of the stack as a percentage of the handset price, which is Google's handset price, not Apple's. And by agreeing to work in DPU for Apple and to give them the same dollar price per unit as Google agreed with Optis, we're in fact giving them a price that's substantially smaller as a fraction of their handset price than the cross-check I talked you through. So in that sense, it's an advantage to them. And it's the kind of point that the judge is well aware of. I'm not going to turn it up now, but can I refer you to paragraph 222 little 2c, where he talked about the difference as to whether or not Apple ought to pay 10% of their $1,000 handset price or 10% of $100 of a basic handset. And he said that an intuitive response to that is in fact dangerous because it's probably anchoring. But it's that kind of point. And as I've explained, we agreed and have agreed by going to DPUs to offer them the DPU price that Google have agreed to pay us. And the essence of their case is that Google did a madly overpriced deal, which is not frowned, even for Apple with a significantly higher ASP, to pay the same on. Now, the judge's findings of fact that are against my friend are particularly set out in 268 to 270. 270 is particularly key. I'm not going to ask you to turn it up now because of the time, but I do invite my lords to look at that. And the second point involved my friend taking absolutely every step in the argument that he went through, involved him taking the highest value possible. So, for instance, he took the free release unpacking of Mr. Bazant instead of the simple that the judge obviously thought was more appropriate because he used that in his cross-check. He then said that you could assume that it was 1% and said, well, even if you halve it, because of I assume that was for the number of units point, it's still not good enough. But if you took the simple unpacking and you took account of the uncertainty because of the number of units, you are a lot lower than my friend was getting to. Again, because of the time, I'm not going to turn it up now, but he was looking at those numbers in my appendices to my letter. And then what he did is compare it to a number that he went to a different case on for a basic price of a phone. So he then went, I think it was to Interdigital, and found another number. I'm not worried about Hollington and Hugh on that either. I think it was an average for a basic smartphone, which was much less. Can I summarise what he did in 6 points so that my lords have the picture? As I said before, the distinction of expressing a price in DPU or AV only matters when you move between the implementers. That's point 1. 2, we accepted to offer the same price expressed as a DPU that Google had agreed to pay Optis. Point 2. That Google agreement is a good comparable, as I've explained, on the judge's findings of fact, not challenged by a respondent's notice. They are to the effect that it's a good comparable, but they say Apple shouldn't pay the same as Google. That's point 3. The window of dispute over what the DPU unpacks to is a number that Mr. Bazant unpacked using Mr. Blasius's projections to about half of that using Miss Guttridge's source. We know it's in that region. That's point 4. Point 5, even at the top end of the DPU price range, it's in fact not shown to be unreasonable with a top-down cross-check, well within the margin of error for the stack size, as I've explained. Point 6, that's actually expressed as a fraction of handset price for Google. So it's in fact substantially lower Google's handset price. They're still a relatively expensive one, but it's nowhere near even a 10% stack, so a 10% price for Apple's handset. So, my lords, the upshot is that Apple says Google agreed a madly expensive price, even expressed as a DPU for them, they shouldn't have to pay it. They want to pay nowhere near what Google agreed to pay Optis. We say it's obviously a good comparable, by far the best available, and my lords should pay close attention to it. I hope my lords are not going to chop me off just yet. I don't think I've not quite had my 35 minutes.
Quite yet.
Not quite yet, but I've got a couple of things to say on the US proceedings. Perhaps the key thing is this. My friend had no answer to the point I showed you on the pleadings, that we were both contemplating the Texas proceedings would proceed to a final damages award. Specifically my pleading he didn't go to, or at least not on that. What he tried to do is to say, well, don't worry about the position statements that were served just before the trial, which made it absolutely plain. Because the markup came in, and it was anticipated that there would be markup of the licence, that is on the pleading. So the essence of the argument was that superseded the pleadings. That's not a fair way of looking at it in my submission. And in particular, he had no answer and did not go to paragraph 58 of our position statement. He just went to paragraph 42 and made an argument about us not doing anything other than relying upon it for value. And just on that, my friend also didn't have an answer to the dichotomy that I identified by explaining that you don't need the kind of evidence that he said there ought to have been if you actually have a situation where you're letting the final award come out of America. It's only if you're compromising that claim, how much is the appeal worth, what are the prospects, that other category of cases is where you might need that evidence. And he just carried on and made the submissions as if that was all he had to do. He didn't attempt to grapple with the fact that, in fact, you don't need that evidence for that second type of case. My lord, there's a kind of whole list of miscellaneous points which I don't think I'm going to have time to deal with properly. A couple of really quick points. On ground 5, he tried to suggest we relied upon 2 of the 3 agreements in our skeleton. He didn't show you paragraph 190 in the extract of our skeleton where he opened it up, where we made it plain what the pleaded case was and went on to explain what was in the evidence and why. We were not seeking to bring 2 of those extra 3 licenses back in. My friend also made various points on table C and D in his letter. Can I just give my lords the references to where we answered those in correspondence? So his table C in his letter, sup 4 we answered it, tab 25, page 220 to 221. The same page answers some of what they said in table D, but my lords also need tab 28 at page 228, where we also answer the table D point. The final point is a matter of housekeeping, and it's this. We have sought to deal with the rounding issues that we said we were going to deal with, and we've put in the further printed out appendices identifying where it made a difference, which was very few instances. In the letter, we have also explained the point that I couldn't explain to my Lord Justice Birss about why the rounding makes a significant difference, or might do. Can I give my Lord the reference to that? It's in tab 30 in sup 4, page 234, and I'll try again without turning it up. Assume that the numbers, the average numbers with Google in, are different, but they both round to the same 2 decimal place. You take Google out, they average, they're still different, but they're now either side of the 0.5, so they average to a penny apart. And because the numbers of sales are so enormous, we're talking about 15 years of sales here, that penny difference means that it looks like there's suddenly a big difference. And that's what I was trying to explain to my lord. I've done that at a bit of a lick. Are there any other questions that I can help my lords on?
No, thank you very much.
That's it.
So thank you very much, all of you, those who have had speaking roles and those who have not. You will be staggered today that we are not going to give judgment here and now. In the normal course, you will obviously receive judgments in draft for you to correct our English and typing, but not so that you can re-argue the case. And we'd be grateful if at that stage you would seek to agree an order dealing with consequential matters. If there are points on which you can't agree, can we please have brief written submissions, and we would expect to settle the points in the order that we make. And finally, although I know you will all be very well familiar with this, I ought to remind you of the importance of the embargo. If you think of anybody else who ought to see the judgments in draft, then you should obviously come back to us. It might be, depending on what's in them, that we ask my lords if we can show it to our accountants. I mean, I follow that, and all I say is come back to us. Certainly, we will do, yeah. So thank you again.